Okay, well, it looks like we've got quite a number of participants who have joined, so we might all get started, I think. Welcome everyone to our webinar to discuss how regulators can incentivise investment and innovation. As you would have seen from the invitation that you all received, we're going to be using the case of Australia's online marketplaces, which has recently been the subject of an Australian Competition and Consumer Commission study. And with our experts, we're the impact of regulation on firms' incentives to compete, invest and innovate. This, of course, is occurring in the context of the broader debate that's going on all around the world as to what, if any, regulatory frameworks might be needed for digital platforms. So that's what we're going to cover today. First of all, I'll introduce our panellists. First, we have Philip Williams. Philip leads the legal and competition team at Frontier Economics Asia Pacific, and prior to that had a long history of teaching law and economics at the University of Melbourne. We also have an Australian perspective, Stephen King. Stephen's a commissioner at Australia's Productivity Commission, and he was previously a commissioner at the ACCC. Philip also has a long history teaching economics at Melbourne and Monash universities, and has, I think, unique amongst our panellists, the role of a lay member of a court, the High Court of New Zealand. So that brings a particularly unique perspective, perhaps. Finally, we have John Yun, who brings a more international perspective. John's Associate Professor of Law at the Antonin Scalia Law School at George Mason University. John's also the Deputy Executive Director at the Global Antitrust Institute. John brings a bit of a regulated perspective as well, having spent a long number of years, I think, as Acting Deputy Assistant Director in the Bureau of Economics Antitrust Division at the US Federal Trade Commission. So we have a very expert and experienced panel who can bring a whole lot of different perspectives to our topic for discussion today. The format of our discussion is going to be as follows. Philip is going to start off running through a short presentation of some issues or ideas arising from the ACCC's recent study of online marketplaces. Then we'll have some brief comments from John and Stephen, and then a discussion amongst our panellists, giving different perspectives on a range of topics and questions in a roundtable kind of format. We'll have 15 minutes or thereabouts at the end to have Q&A from the audience. Please, as we're going along, if there's a question that occurs to you, put it in the chat function that I know everybody's super familiar with from our years of virtual living, and we'll make sure we address those questions in 15 minutes or so at the end of the webinar. So with that, I'll hand over to Philip. Thank you, Philip.
Thank you very much, Kirsten. I'll just share my screen so that people can see my slides. Okay, thank you very much. In February this year, the ACCC released a discussion paper entitled Updating Competition and Consumer Law for Digital Platform Services. The discussion paper floats a number of proposals for changes to the law relating to digital platform services. In this short talk, I shall deal only with the proposals concerning the prevention of anti-competitive conduct. That is the ones in the red. I shall relate the proposals to the ACCC's remarks about online retailers in its interim report on general online retailers, which was released 1 month later in March. I've been invited to give this talk because Frontier Economics was asked by the Amazon Australia shop to make a submission to the ACCC concerning the discussion paper. I shall make 5 short points in this opening. The first is that the ACCC adopts an implicit definition of the market confined to specialist online retailers, and this makes no sense. The discussion paper distinguishes online retailers from traditional bricks and mortar retailers. It states, the purposes of this report, a distinction is drawn between online marketplaces and traditional bricks and mortar retailers that also operate online, such as Big W, David Jones, Kmart, Myer and Target. Online marketplaces facilitate transactions between third-party sellers and consumers on a common platform, while traditional bricks and mortar retailers act online as the seller. In this way, online marketplaces take an intermediary role between consumer and sellers, whereas traditional retailers that sell their own products online do not. In my opinion, this reasoning is misleading. It is misleading for two reasons. In the first place, specialist online retailers, such as the Amazon Australia store, sell products as a retailer in exactly the same way as David Jones and Myer. And secondly, specialist online retailers, such as the Amazon Australia store, offer marketplaces where independent sellers can sell products directly to consumers, again, in exactly the same way as David Jones and Myer. It makes no sense to define an implicit market confined to specialist online retailers. My second point is this. As the ACCC acknowledges, general retailing in Australia is a highly competitive industry. The ACCC makes the point that the sales of specialist online stores have been increasing as a proportion of total retail sales, but this has been from a very low base. My third point is that the lack of significant market power in the specialist online retailers implies that any gains in sales must result from competing on the merits. If businesses lack significant market power, they can only gain profits by competing on the merits. That is, by competing by expanding the size of the pie rather than merely redistributing a given pie. They can only gain share by competing effectively, by innovating and generating cost efficiencies for the benefit of customers and suppliers. Almost all antitrust disputes come down to a question of whether the conduct at issue involves generating economic efficiencies or whether it generates profit by stitching things up. If a firm has no significant market power, the assumption must be that its conduct generates profit by generating economic efficiencies. Even though online retailers in Australia lack any significant market power, the ACCC's discussion paper suggests that new regulatory constraints might be imposed on digital retailers if they reach what it calls any requisite thresholds linked to market power or strategic gatekeeper status. Although the proposal is vaguely worded at this stage, it seems to follow the EU Digital Markets Act, generally referred to as the DMA. The DMA is an extreme form of ex-ante regulation. It designates as a gatekeeper a provider of core platform services if it meets three sets of quantifiable criteria. One, it must be big in terms of turnover or market capitalization. Two, it must operate a core platform service that serves as an important gateway for business users to reach end users. And three, it must enjoy an entrenched and durable position in its operations, or it must be foreseeable that it will enjoy such a position in the near future. If these criteria are met, then the provider will be designated as a gatekeeper unless the designation is successfully challenged. The DMA provides for a set of constraints on all gatekeepers in their interactions with business users, final customers, and competitors. The constraints imposed on these businesses have nothing to do with bad conduct. They are imposed as a form of ex-ante regulation in order to prevent bad conduct from occurring. My fourth point is that ex-ante regulation of this kind is likely to reduce incentives for online retailers to compete on the merits and to favour bricks and mortar retailers over specialist online retailers. As John Vickers has said, non-dominant firms need assurance so that their competitive conduct is not chilled and they are not at risk at findings or even investigations of abuse. The constraints proposed by the ACCC's discussion paper have nothing to do with bad behaviour. The proposal, as applied to online retailers, is that firms that gain size by competing on the merits will have their operations constrained once they meet certain thresholds. This will create a disincentive for firms to compete on the merits. Unless the lawyers among you think that only economists have these strange views, such as John Vickers and myself, I quote Judge Learned Hand in the famous Alcoa judgment. He says, a single producer may be the survivor out of a group of active competitors merely by virtue of his superior skill, foresight, and industry. In such cases, a strong argument can be made that although the result may expose the public to the evils of monopoly, the Act, he's referring to the Sherman Act, does not mean to condemn the resultant of those very forces which it is the prime object to foster. Finis opus coronat. The successful competitor, having been urged to compete, must not be turned upon when he wins. My fifth and final point is that the proposal and its implementation will create regulatory uncertainty, which will reduce incentives to invest, innovate, and undertake other strategies which would otherwise constitute competition on the merits. The extra uncertainty is of three kinds. Uncertainty about the nature and level of the thresholds, even once they have been defined in legislation. Secondly, uncertainty about how specific prohibitions, for example, as to access, will be applied in particular circumstances. And finally, uncertainty about whether and how thresholds or prohibitions may change in the future. There is a sizable economics literature on the effects of uncertainty on the level and nature of investment. There is a much smaller literature on the effects of regulatory uncertainty on innovation. However, the UK's Competition and Markets Authority 2020 report on competition and innovation concluded that greater regulation is on average associated with lower competition, but noted, as I've mentioned, that there are real gaps in our knowledge of the effects of specific regulation on innovation. Australia should tread very cautiously before adopting further regulatory constraint on competitive industries. Thank you.
Thank you very much, Philip. We might now turn to John for some introductory remarks, John.
Thank you, Kirsten. And let me apologize up front if the background noise is really loud. I'm at the Wild Dunes Resort in South Carolina, and it's late here, and people are enjoying cocktails, and it sounds like they're having fun, but they're also loud, so I apologize for that. So with that disclaimer, the remarks are really excellent by Philip, and I agree with his points. And I just want to take one theme and just kind of ride with it for a couple of minutes. One of which is this sort of the nature of these businesses. I think these interim report type reports, I've seen it in other reports as well, and it's a very common sort of approach to these businesses is that they list things such as network effects and platforms and tipping and sort of winner take all types of paradigms, and they apply it across businesses irrespective of the specific nature of the business. Just to give you an example, something like Facebook is what we would consider sort of your classic direct network effect where more users sort of increases the value for other users. And I think that's a standard, common approach to analyzing that market, and that makes sense. But if you examine something like Amazon, it's really a mix of numerous businesses, one of which is a vertically integrated retailer like a Walmart or Target here in the US, where they are effectively the wholesaler and the retailer. That's not a platform under the traditional definitions that economists use. But it also has a very important part of its business, this Amazon marketplace, which acts a lot like eBay, where it's bringing together the sellers and buyers as a common sort of place virtually for them to interact and transact. That's more like a platform, but even there, it's very different from Facebook, right? You have a situation where you have these cross-group network effects that obviously more sellers begets more buyers begets more sellers, but there's no real strong direct network effect where more sellers means more sellers or more buyers means more buyers. Just to give you an example, if you buy a mouse pad or a mouse on Amazon last month, there's no reason just because other people bought mouse pads on Amazon that you're inclined to go back to Amazon, or whether you're inclined to go back to buy your laptop or ink or printers or whatever it is that you're interested in buying on Amazon. Those effects don't tie and link you to that product. So long story short, popularity for online retailers doesn't mean tipping, network effects, that we're sort of cascading towards a winner-take-all scenario that we have to be really worried about. The switching costs online are very minimal, and it's not clear to me that people are locked into a retailer online because of network effects or tipping. They're locked in most likely because the terms of service are excellent. So, I really think when we get into the business of analyzing these online marketplaces that we really get a little bit more precise and sort of stay away from these ideas like tipping and network effects and winner take all. I don't think those really apply in all cases.
Thanks very much, John. Stephen.
Thanks, Kirsten, and thanks, Philip, and thanks, John. I think Philip's paper, largely agree with it. So I'm going to just make some introductory comments around Philip's paper. So the first is that Philip is reminding us of something very important in all regulation, that investment and the incentives for investment are always affected by regulation. And whenever a regulator introduces new regulation, they seem to forget about that. Philip, for example, refers to some work that I did probably 20 years ago when we were looking at access regulation in Australia and the same issues of whether investment will be affected and will that be deleterious. So the first point I really want to make is that it's not just ex-ante regulation that we need to think about the issues that Philip has raised. It's all regulation. I'm not sure that it's more problematic or less problematic for ex-ante versus standard competition regulation. I think they all have investment incentives. The question is, what are those incentives or what are the disincentives, and should we worry about them? Second point is just Philip concentrates very much on the platform or the business incentives for investment. And I think that's the natural starting point. I do think that the ACCC has a case when it takes it broader. So when we're talking about a platform like Amazon, there are at least 3 different participants. One is the platform, and we should worry about the incentive for the digital marketplace to invest. But we should also worry about the incentives for the sellers to invest and the incentives for consumers to invest in that relationship. So I think all of those issues of investment are important. The question, or the point that leads on to, though, is that any introduction of new regulation needs to be associated with an analysis of the investment incentives and disincentives, and there needs to be an appropriate cost-benefit weighing up of the disincentives and the potential costs versus the benefits. And unfortunately, I just do not see that in the ACCC's paper. The third point that I would like to make really reflects Philips competition on the merits. And I think that is, I want to expand on that key point. So Judge Learned Hand noted that we don't have competition laws that say you have got market power, therefore you can't charge prices higher than your costs. If there's competitors there, there's others can come in. If you lower the quality of your service, there is no problem. The fact that you are making profits, the fact that you may be the dominant player in a market is not by itself a problem from an economic perspective. If you get there by serving consumers better, then good on you. Now, lawyers may have a different view, but certainly what I just said was standard in economics, and we wouldn't want to see anything else. I think I'm down to point number 4, just in there. So I guess the fourth point, and this will be my final one on Philips paper, Philip illustrates those potential costs from that ex-ante regulation. He refers to truncation. But I think both from Philips' analysis, and Philip can probably rightly say, well, I'm responding to the ACCC and they don't do this. There does need to be that fulsome asking of the relevant questions. Philip did some of that, and I think he did it better than, in some ways, the ACCC paper. So he looks at market definition. He asks, well, bricks and mortar in the same market. The ACCC paper never does that. He asks about, well, is there likely to be entrenched market power? But again, what we really are missing here is that cost-benefit analysis. What are the costs of this regulation? And is this regulation actually worthwhile? Or, in fact, is it more likely to make Australian consumers worse off overall? So let me leave it there, Kirsten.
Thank you very much, Stephen, and thanks all three of you for canvassing many issues that we could delve in and discuss for days, but we only have another 35 minutes or so. So we might start with Stephen, your fourth point about the right questions that should be asked. And one of those questions was, what is the right market definition? What is the right approach to market definition? And market definition, even from the perspective of a competition lawyer, that's where competition analysis starts. How do you each think that what is the right approach to market definition here? Who would like to go first?
Happy to jump in, seeing I mentioned it.
Yes.
Yeah, so market definition should be done on the standard basis of substitution. Looking at, starting off on the consumer side, asking what do consumers choose between? One person on this seminar, who's happily just texting me, is busy buying a bit of equipment on Amazon as we speak. I'm quite sure that same person would otherwise duck down to Officeworks for that bit of equipment. Is there substitution between online marketplaces and bricks and mortar marketplaces? It would seem from the ACCC's analysis that the answer is yes. And in fact, bricks and mortar marketplaces are much larger than online marketplaces. Their own numbers suggest, yes, digital marketplaces are growing, but they're tiny compared to the bricks and mortar world. My starting point would be to say, on the basis of the ACCC's analysis, we have a retail market, which includes bricks and mortars and digital marketplaces, and that would change the analysis a little bit.
Okay, I think, Philip, you put your hand up very politely.
I did, because I think the ACCC, I'd like to think Stephen was right, but I think the ACCC has an implicit market definition. You define markets because that is the field in which you conduct your analysis. The field in which the ACCC has conducted its analysis in its March report on online digital marketplaces is confined to online specialist digital marketplaces. So it has implicitly defined its market by confining its analysis to online digital marketplaces. The point I was making in my paper and in my presentation was that its reasons for doing this are just wrong, just factually based on factual mistakes. And that's really my point. I do think that there's no one right way of defining a market. It really depends on the problem you're analysing. But whatever the problem the ACCC was analysing, the reasons it gave for confining its analysis to specialist digital marketplaces were not based on facts. They were, mistaken.
John.
Thank you. I'm going to combine a little bit of what Stephen and Philip said. The most troubling quote is something that Philip had on his screen. Let me, if you'll indulge me, reiterate the sentence. Online marketplaces facilitate transactions between third-party sellers and consumers on a common platform. That sounds very, very innocent and true, while traditional bricks and mortar retailers act online as the seller. So what's happening here is, again, something I see very common. They're elevating the business form over the substance of the competitive analysis. And the fact that Amazon operates differently than a traditional retailer doesn't mean that consumers don't perceive the products they're purchasing as a difference in terms of substitutability. They might, but we can't arrive at that answer just because they have a different business model. Just to give you another illustration, I think most people would accept taxi cabs and ride-sharing apps such as Uber substitute, at least for some riders on some trips in some cities. And they have very different business models. And so this idea that Amazon operates differently as a platform, so as a consequence, we're almost going to have a presumption that they don't compete with brick and mortars who also operate online. I think, to me, that's very troubling because, again, we're looking at business models rather than looking at specifically the competition on hand. And just to give one potential criticism of what I just said, one could think, well, look, you can't be a third-party seller and go on Myers or Kmart store. That's their store. So, Amazon's the only game in town other than eBay. And so as a consequence, we're worried about them rather than the consumer themselves. Of course, you wouldn't say it that way. But that's the concern, is that now you're looking at the inputs into the ultimate delivery of the product to consumers. Again, Amazon does it quite differently than others. And now we're looking at the welfare of other third-party sellers and now weighing it with consumers. If you want to do that, that's fine. But competition law has been served really well by focusing on consumers because it's really complicating the analysis. So there is a difference. I did want to put that caveat in case there are those who see that, and I agree with that. But again, the ultimate arbiter is consumers.
Thanks very much, all. Perhaps we'll move on to what seems to be the concern that the ACCC has identified in its report, acknowledging that it does, that online marketplaces haven't reached a dominant position in Australia. But the concern, as articulated by the ACCC, is that there is a potential for the market to tip in favour of a single dominant marketplace, and that the ACCC would have significant concerns if tipping led to a dominant marketplace behaving anti-competitively or reducing the benefits to consumers or sellers that would otherwise gain from competition. So there's a few concepts in all of that I thought might be worth discussing amongst the panel, and perhaps starting from the notion of tipping. Is tipping inherently a problem? Can tipping occur because an entity competes on the merits? Does it necessarily follow that if a market tips that a firm is going to behave anti-competitively? Perhaps John, you're nodding the most vigorously. You might like to kick off lead us off on those topics.
Thank you. Yeah, I love the tipping discussion. It's a great one. And, traditionally tipping is associated with network effects, direct network effects, where if you're the first mover, such as in VHS versus beta, that was a big question, different music formats or the radio in terms of the types of formats that you want and the receiving that you have of that. All those have standard networks that have this standard tipping implication that once you get something started, everyone goes onto that standard. And even if you have a superior standard, it's hard to move over. You know, when you apply that word to online marketplaces, I'm not even sure what that means. Is it a proxy for popularity? Because if it is, then we're invoking a literature of network effects and tipping in a way that I don't think is sustainable for these types of markets. So going back to what I said earlier, I just think we should be really cautious of applying tipping, which I know the interim report does, for these types of markets, because it's not clear to me that the network effects work in such a way that you would tip because you have first movers. If so, eBay would have tipped the market, right? Or others who have before Amazon. Amazon is the entrant here in Australia. And so if tipping would occur, or that's a characteristic of this market, we should be observing that. But since we're not, just because, let's just hypothesize Amazon over the next 5-10 years becomes immensely popular, and then looking back and say, we saw this coming as tipping, again, I think we're assigning a word to something that's just popularity and just gaining shares as on the merits.
Thanks, John. Stephen, is there a tipping problem here?
Yeah, so my starting point would actually be, in the case of digital marketplaces, no. So the first thing you look at for tipping is you ask, is there an issue of single homing, as it's called, for platforms? So in other words, would sellers be locked into one platform? Would buyers be locked into one platform? Most of the economic analysis of tipping assumes that. It's done for platforms where a consumer has to choose one platform and a seller on the other side has to choose one platform, the two parties. There's no evidence, as far as I'm aware, of that for online retail platforms like Amazon, like eBay. The ACCC's own report makes it very clear that both sellers and consumers multi-home. They choose a variety of platforms to go and buy on, and they choose a variety of platforms on which they can sell, including direct-to-public websites using backup services like Shopify. So in that situation, could you get tipping? Well, yes, but it is a lot less likely. How could you get tipping? Exactly what John says. Do we have such strong network externalities or network effects that we would think, even though we can have multi-homing, even though you can choose different platforms and operate on them at the same time as, say, a seller or a buyer, that they will be overwhelmed by these network effects. It's you know, the Google effect, the feedback effects from data are so strong that you get a position of dominance. Well, the ACCC mentions that, but again, for digital sellers, digital marketplaces, there really isn't a great deal of evidence that data has the increasing returns that you would need for tipping to occur. If anything, once you have 1 million middle-aged white males like Philip and myself, and the data on them, I'm not sure the millionth and first bit of data is going to help Amazon sell something to Philip or myself. It's quite possible, it's quite reasonable for multiple platforms to have access to similar data sets at the same time and be competing against each other. So I see no reason why we're going to get tipping here. It's just assumed by the ACCC.
Philip.
Well, I agree with everything John and Stephen have said. I do think there is a danger of which John alerted to, and it's this, that if one particular operator does emerge as the largest, clearly, then people may retrospectively say, oh, this is as a result of tipping. But you shouldn't do that. I mean, this was well, some of you might remember the US Department of Justice prosecution of IBM in the late 70s and early 80s. You may not remember it, but you may have read a book, a wonderful book that Baumol wrote called Folded, Mutilated and Spindled, which was about the attempt to prosecute IBM. IBM was being prosecuted for monopolizing the US computer market. But as Frank Fisher argued, sorry, the book was written by Frank Fisher, not by more. As Frank Fisher argued in the book, one explanation of being large is that you're efficient. Another explanation is that you've been stitching things up. And what he argued was that IBM had gained a very large market share because it managed to stay ahead of its rivals every time, and their rivals were playing catch up. One should be very careful to distinguish these two alternative explanations.
That seems like a good moment to move on to another topic while Philip unfreezes. The HPLC, I think, does acknowledge, or my reading of the report anyway, that there may be a distinction between the fact of tipping and then behaving anti-competitively. And I think the report says the HPLC would have concerns if tipping leads to a dominant marketplace behaving anti-competitively. I was interested in your thoughts of the distinction, if there is one, between just the fact of tipping and behaving anti-competitively, which seem to be two separate concepts, but which seem to be quite often, conflated together a little bit in the discussion. What do you think of that, Stephen?
Okay, so it really comes back to the basic issue of, tipping means that a business will have market power. We don't automatically assume that a business with market power is going to violate Section 46 of Competition and Consumer Act, abuse its market power. So really, the standard approach should be, if there is tipping, then what is the firm abusing that market power? And really, the question then becomes, well, why isn't our current competition law enough to deal with that threat, that possibility? One of the points that Philip didn't mention in his presentation, but is in his paper that I've had the chance to read, is that the starting point for introducing new regulation for online marketplaces should be to say, there's a problem with our existing regulation, that Section 46 in its newest guise is unable to deal with the abuse of market power that may or may not emerge in the future on these marketplaces. The test has never been done, and I think that's a real problem with a lot of the work that we're seeing in digital platforms. That the basic question, well, where's the problem in our current laws? Why are they not up to the task? That isn't really being asked. It's just being assumed we need new laws for these new business models.
John.
Yeah, so, you ask a really good question, because it seems to me, after reading so many of these reports across all jurisdictions, that the original sin that firms make is to have market power. And what that does is it's an inclination to further sin and do things that are sort of outside the bounds of fair competition. It just seems to me there's been a move from market power, it allows the possibility of anti-competitive harm from a dominant firm, to there's sort of a presumption that even with tipping, if tipping's the measure by which you obtained and keep that market power, that has a little bit of a shading of a presumption that it's inclining you to do something bad. Just to give you an example, something like self-preferencing, which back in the day we used to call, just shelf space, effectively virtual shelf space, where you're trying to promote your own product and give it a little more prominence. It happens across industries, across market powers, whether you have 1% share, 5 or 50, you see this as a very common practice, not only for private labeling, but to promote your private label product in a prominent position, whether virtually or physically. And so what I find curious, though, is once you gain that market power, everything has changed in terms of the lens in which self-preferencing is perceived. Now, I'm okay with that because it allows it being market power, allows the possibility that self-preferencing now can be used in a way that forecloses or raises rivals' costs. That's fine. Those are acceptable theories. But it's also, to me, acceptable that they're being used in a pro-competitive way in the manner that those who don't have share have. And so I think it's really important to look at the history of the practice, whether it's widespread in an industry. And I think it's important that Amazon, they have 2% share in Australia. Can we observe their practices today and see if it changes over time? And if they keep doing what they have been doing to be successful, maybe the presumption could go the other way, that what they're doing is actually benign and helpful because that's how they grew their share when they didn't have market power. So I just see the shading of a presumption, whether it's tipping or not, that market power gives. And I'm not sure where that came from, but it seems to be definitely a thread in these reports.
Stephen.
Yes, so just, okay, two things I want to follow up from just what John was saying there. Yeah, the first is, and John, you probably haven't had the joy of reading our Competition and Consumer Act. What you described in terms of, wow, did behaviour change over time? That sort of describes our old Section 46, which is abuse of market power. It's been broadened since then. Unfortunately, we don't have any real precedent. I think, Kirsten, you probably know much better than I do, but I think there's really only been the one case that was settled and involved some ports down in Tasmania. We don't have precedent on how much further we can go, but there is an open question in Australia as to what behaviour is going to be caught by that new abuse of market power law, and how broad can it be? Because you can have power in one market, but if you then engage in conduct that substantially lessens competition in another market, you can be breaching our new Section 46. So there's some open questions there. And if we're thinking of investment and uncertainty and so on, it'd be good if we could solve for ones on Section 46, but I think we need a few cases. The ACCC seems to be reluctant to bring them. The second point that I do want to say is, to the degree that, and I agree with you entirely, but reading through the ACCC's paper, one of the things that stood out to me was, oh, we're against self-preferencing. I don't know, I walk into Coles or Woolworths supermarkets and I look at the best shelf space, and guess what? That's where the home brand is. We need more transparency to sellers. Well, I can remember doing a grocery inquiry about 10 years ago when I was at the ACCC, and a key element of that was the fact that there was a lack of information to sellers on them being delisted, and there still is. So, you know, the sort of issues they bring up aren't unique to online digital marketplaces. Final bit, if they're really worried about tipping, let's go back to that. If the ACCC's concern is we are worried this market will tip, then there are things that they can actually do which can help prevent the tipping. And they don't seem to be discussed. It seems to be this presumption that it's going to tip. So, for example, do we see exclusive contracts? Do we see online marketplaces saying, like, you know, let's say Amazon's the one we're worried about it tipping to. Do we see Amazon going out and saying, guess what? You're a seller on our marketplace. Don't go to any of those other marketplaces, because if you do, you're off ours. If we started seeing that sort of contract that forces single homing, a choice, a forced choice by the seller, then I'd start having some concern. But as far as I'm aware, we haven't seen those contracts, those type of exclusive contracts. If we saw most favoured nation or most favoured customer clauses. So if Amazon started saying, hey, if you're selling on our platform for this amount and you're selling on eBay for less, or you're selling on your own platform for less, hey, guess what? You're off our platform. Then I would start seeing the concerns. Those sort of contracts that reference rivals that we've seen being dealt with in under Hotels.com, the case in Italy, in Europe. As far as I know, they don't exist, and certainly the ACCC doesn't present any evidence that they exist. So in the absence of those, yeah, I just think the ACCC is worried or putting in place or is trying to put in place regulation for something that we don't know is going to occur. And, you know, it comes back to Philips. There will be costs to this.
Thank you. That might be a good point to move to the discussion of Philip's points or everybody's views on the notion of regulatory uncertainty that Philip touched on in his presentation. The ACCC, of course, in its paper says that if there is a framework that's going to be developed to address competition concerns caused by digital platforms, that framework should be capable of applying to an online marketplace should it attain substantial market power or occupy a strategic or gatekeeper position. So that's a pretty high level articulation of what a framework might be. John, what are your thoughts on the effects of a kind of a regulation that might apply in a particular form that's not clear now to someone in the future?
Yeah, no, and I'll just have some brief thoughts on that, because to me, it should be really obvious to everyone that uncertainty is when businesses really do not thrive. And even if you're going to have bad regulation, sometimes it's better to have certain and clear bad regulation than sort of this threat of regulation down the road. I think that can be really damaging, because what? Are you really going to invest heavily and in innovation and in long-term sort of goals in a certain market when you don't know the regulatory environment and whether that's going to get you into trouble or not? Now, that being said, you know, one thing I do agree with Philip, and he makes a really good point that uncertainty will really create this disincentivizing effect on Amazon. I clearly think that's directionally right. I must say, to be fair, Amazon still today, even in the US, has much less than I think what most would consider dominance online. Even the ACCC said it's 30, 40%. If so, you know, and they've been here in the US a long time, perhaps we maybe shouldn't be as worried, because even if Amazon is wildly successful in Australia, I think that would be 20, 30% if it's similar to the US. And so, you know, maybe that's less of a worry for me, that it has this disincentivizing effect. But clearly, the uncertainty is something that's quite bad.
Stephen, what's your perspective on regulatory uncertainty?
Yeah, so as I said at the beginning, I think all regulation will have incentive effects for investment, and I'd probably be broader than Philip looks at ex-ante regulation in his paper. I think ex-ante, ex-post, it all has effects on investment. The thing that I find most worrying about the gatekeeper sort of framework that is being proposed is probably the lack of detail about how gatekeepers will be defined, what is the process for it being defined. And let's come back to access regulation. I mentioned this earlier on. You know, 20 years ago, we had a big debate in Australia about our third-party access regime, Part 3A as it's become. Part 3A has very clear declaration criteria. It has an arm's length process for a body, the National Competition Council, which is separate from our competition regulator, to analyse those criteria and make a recommendation to the minister. There are processes in place to appeal a declaration under Part 3A. Will we, and does the ACCC envisage that we will have the same sort of things for a gatekeeper declaration? So at what point, let's say Amazon starts winning big in the online marketplace world in Australia. Let's say it gets to 70% of online marketplace sales. Who decides it's now the gatekeeper? What are the criteria for it to be a gatekeeper? If the party deciding it going to be the same party who is then going to be prosecuting it for violations of a competition law? Or is there just a fundamental conflict there? If it's not, what's the arm's length process? What are the rights of appeal? And you know, my concern is that once you've gone down this path and you've actually created a regulatory regime rather than a regulatory thought bubble, which is I think where we're sitting at the moment, then you know, the main argument for this ex-ante regulation that, well, we need to move things faster. If we rely on our competition laws, it takes too much time to go through the courts. Well, Part 3A has done many things in Australia. One thing it has not been is fast. And so, you know, the problem for the ACCC is it sets up a new system that will be at least as time consuming as the existing system without any obvious benefits relative to just straight competition laws that we have in place.
Thanks, Stephen. Philip, yes, you're back.
Yes, I've left very short periods. There is, I think, a big difference between the form of access regulation that we have in Australia and what might be proposed under this sort of ex-ante form. And it's this, that the investment to which access regimes apply are very old investments on the whole. They're well-established things like railways and electricity wires and ports and whatever. Whereas the investment to which this is applying is investment that's being undertaken at the moment, not 100 years ago or 150 years ago. And I think that's a real difference between the access regime that we have in place and the access regime that is being proposed by the ACCC.
Thanks, Philip. I think you've all touched on the importance of, if you are thinking of regulating, the importance of really analysing the costs and benefits of the proposed regulation, which I suppose has a threshold question of the more precise details of that proposed regulation. But I thought maybe perhaps starting with you, John, how would you approach doing the sort of cost benefit analysis that has been touched upon in our discussion?
Oh, that's a really good question. You know, the part of it is where have we seen similar regulation and what's the effect on firms? That's usually a good starting point, in that it gives us at least some paradigm as to where these types of harms might occur to the firm being regulated and potential benefits. I'm not aware of any. So imposing these type of gatekeeper things obviously is on the cusp. So to me, a lot of these costs and benefits are uncertain. We're speculating on both sides. I haven't seen a clear sort of case and balance being made. But let me just illustrate the difficulty of this exercise, even though based on principle, this is what we should be doing. Look at what the EU shopping case has done in Europe. That's a 12, 14-year journey where they are trying to assess the benefits and costs of self-preferencing and integrating some of your product and promoting it. So what are the real costs to society? Well, it's taken courts almost 14 years or regulatory agencies to figure this out. So long story short, I don't think we're, as much as we call for it, I don't think it's that realistic that we could have anything precise. It's a high bar to meet for the ACCC or any government regulators. So the question then becomes presumptions, and that's a big conversation that people have. But I think that's ultimately what we'll have to rely on.
Stephen, you mentioned a couple of times the need for a cost-benefit analysis. How would you do it?
Yeah, so John's exactly right. It would be, in this situation, as in most practical situations, it would be very rough and ready. The issue for the party doing the cost-benefit analysis is always going to be a useful term in this space, data. We're dealing with digital platforms where the ACCC is making claims about their data. Well, the ACCC needs data on what's going to, what are the costs going to be, what are the benefits going to be. And yeah, you run parallels where you can. So for example, when we're looking at, are there benefits through having a clearer, more transparent and faster turnaround time by having gatekeepers declared ex ante? Well, and I agree entirely with Philip, the investments are entirely different, but that's not the comparison I'd do here. I'd say that is a fairly recent regime which gives us a good idea of timeframes. is it going to be faster than the 15 years for Google Shopping? Well, however long Google Shopping's been going. Maybe, but again, there's a long process in place, and we've got the Fortescue's middle case to provide that. So I think there are parallels there. I'm not saying that investment is the right parallel there, but I am saying that I think we can see some parallels there. Can we use presumptions? Well, yes, I think we can in certain situations. So, for example, I said if I saw exclusive contracts out there being done by Amazon, or if I saw most favoured customer contracts with Amazon, would I have concerns about them today? Yes, that is a presumption, but it is a presumption that's based on experience and, in some ways, judgment, legal and economic judgment about what can occur with these sort of contracts. So it would be a rough and ready approach. I do think we have parallels. We have parallels from overseas. We have parallels in Australia. We're not going to find an exact parallel. It's not going to be one of these great economic experiments where you can say, hey, guess what? In the state of Victoria, they introduced a gatekeeper situation, but in New South Wales, they didn't. And let's have a look over the last 10 years and see what happened. We're not going to be doing that. But we can pull evidence from a range of places. And what I would say is never acceptable is to say it is too hard, therefore we shouldn't try and do anything. Because if you accept that, then you may as well just say, yeah, our guess is as good as anyone's, let's do our stuff even though we may be massively wrong.
Philip.
Yes, I agree with John and Stephen. I think that our experience in Australia with our regulatory impact statements illustrates that you really can't do a cost-benefit analysis in the sense of coming up with a plausible dollar figure for the net benefit or ratio for the net benefit. But what you can do, and really John and Stephen have pointed to this, is very careful analysis of what are the benefits and what are the costs of something. So that you can't quantify them and come up with a net figure or a net ratio, I think doesn't mean you shouldn't be very careful in considering what are the benefits and what are the costs of any particular regulation or law that's being proposed. Thank you.
So we're at the hour, so we've got 15 minutes for questions from the audience, if you'd like to send them through. And while you're doing that, we might continue with our conversation. The conversation we just had was really, look, how would you go about assessing the costs and benefits of introducing some kind of gatekeeper type regulation here in Australia, I think, and then reference to looking at a whole range of considerations you might take into account. But Stephen, something you mentioned, which was for you, if you saw sort of exclusivity provisions in an online platform's contracts, that was something you might be concerned about. I would have thought that as a competition lawyer, at least, exclusivity provisions in contracts or most favoured nation provisions in contracts are something which is already the subject to our competition laws. And I just wanted to explore with you whether you were giving those as examples of conduct that hasn't been seen but could be concerning, but not necessarily conduct that needs a gatekeeper regulation to address it.
Oh, no, yeah, that's exactly right. If you wanted to, so it's not behaviour that, as far as I'm aware, we've seen in digital platforms, but it is the sort of contract, that sort of conduct where you'd be saying, well, hang on, there's something we're a bit worried about here. And at that point, you'd start the debate, can we deal with this under our current competition laws? And it may be, and I could see the case being made by, say, the ACCC in that situation, where they would say, well, actually, Amazon or eBay or whoever it is doesn't have market power at the moment, but we do have this concern about tipping. So what we would like to do is have a change in the law where these particular contracts for digital platforms disallowed because of that threat of tipping, and it isn't covered by our current abuse of market power laws. I could see them making that sort of argument. That's not the argument that they've made, but I would be, I guess, much happier with that sort of argument, and I think a reasonable argument could be made there. I'm not saying it's a good idea, but at least I could see the argument being made. And the problem is that, you know, jumping from, we may have a problem of tipping to let's go to gatekeepers without asking, how do we come up with, if we want to change the laws, how do we come up with changes that prevent the problem, i.e. creating a gatekeeper, rather than just simply saying, oh, we're going to end up with a gatekeeper, let's put in this other regime. You know, it's, I'd much prefer if the ACCC was dealing in that space.
John, what do you think about Stephen's, John or Philip, Stephen's suggestion that you might put in place a rule that might be directed at platforms to say you can't have exclusive contracts of the kind that we've been talking about? So I'm not using your exact words, Stephen, but the concept of, well, look, maybe we need a law that's directed at platforms and a particular type of conduct engaged in by platforms. Again, as a competition lawyer, that sort of specific kind of provision is something that we saw with the price signalling laws, which have been thankfully removed. John and Philip, what do you think about that kind of specific type of potential regulation?
You know, as you mentioned, exclusivity is something we already deal with. And, you know, the fact that I observe exclusive contracts across market power, across industries. And so when we apply it to platforms, again, it seems to be that we have this presumption that anything they do that's associated with conduct that could be anti-competitive is presumptively anti-competitive. And so, you know, as Stephen said, if we observe exclusive deals as the path to their market power, as the path to tipping, not holding aside which market we're talking about, then I think maybe we start to raise our concern a little bit. But at the end of the day, I think having blanket regulatory prohibitions on certain types of conduct that's commonly observed across market powers and across industries, to me, just like banning all mergers for certain type of acquisition, it's making this presumption that we know it's harmful. And to me, even something that sounds as bad as exclusive deals can have very good justifications in certain instances and markets. Yes, even with platforms with market power. And so we have rules for that ex post. Moving to ex ante, I think we should be very cautious.
Thanks, John.
I'm just would be very skeptical of rules that only applied to digital operators. I mean, I could understand that there may be very particular problems to do with digital operations, but I'd really want to be convinced about that. So, for example, if we think of self-preferencing or transparency or whatever, we have laws at the moment to do with misleading and deceptive conduct. Trivago was fined a very large sum of money recently in Australia, basically for misleading consumers in the way that it portrayed the prices and the order of hotel room rates on its website. So we have laws like that. So the question is, if we want transparency, how much? What are we prepared to do more than that? And what is there something peculiar about digital operations that make transparency issues particularly bad? Well, I'm not sure that there is, but they're the questions I'd want to ask before I was sure, because as we know, there's self-preferencing in supermarkets at the moment, in the sense that they choose which products are at eye level and which are right down the bottom or right up the top. So the real question is, do we want to do more than we've got the rules? And the second question is, are there some particular features about the digital environment that requires extra laws? I'm just not sure about that.
That might nicely lead into a question from the chat box, which is a question I suspect none of us can answer, but the questioner wants to know whether we can expect DMA-like regulations gaining traction in Australia, and what would be the main changes needed to adapt such regulation to the particularities of Australia. Does anyone want to have a go at that? Maybe you don't need to, John, since you're not from here.
Yeah, so I will, you know, we are halfway, slightly more than halfway through the 5-year digital platform services inquiry by the ACCC. We've seen a lot of suggestions for increased regulation, much of it similar to what DMA has introduced in Europe. So I think there's two things. I guess the first is, you know, I think there is a real risk, or you know, some people may say a real possibility, rather than being judgmental, a real possibility that we will see the final result of the ACCC inquiries being recommendations, solid recommendations for DMA type rules. And it's quite possible a government would see those as desirable to implement. So I think that's a real possibility for Australia. The second part, though, is to remember that Australia is a little player in the world market. And, you know, to some degrees, it almost may not matter. Because if we see the major markets, so if we see the EU, we've seen California introducing similar types of laws. If we have the broader laws in the US that are currently being contemplated, and I won't try and remember the exact name of those, John can probably remember much better than I can. If we see them being passed, you know, it's unlikely that we will see different approaches in Australia. It's simply going to be the case that whatever is built for Europe and the US, we will take. So we may end up with these restrictions, even if they're a bad idea, and even if they make the consumer experience better off, because they're not going to build a different platform for Australia that isn't compliant with the EU and the US.
John, Philip?
I'm not going to try and predict what's going to happen, but it's interesting to look at the style of drafting of the DMA compared with the style of drafting that we get in Australia. The style of drafting for the criteria for gatekeeper, apart from turnover and market cap, which are quite specific, the other two sets of criteria are enormously vague. So it's a style of drafting that doesn't seem to appeal to our parliamentary draftspeople. You could imagine what they would do if they were given instructions like this. They'd come up with pages and pages of stuff. I hate to think what would be the result, but it's certainly not the style of drafting that we would get in Australia.
We could have a whole discussion about civil law versus common law systems and the like, but we won't. We've got about 5 minutes to go. I wondered whether we might ask the panelists each to express their view as to what they think is the right vision. Maybe John, starting with you.
Thank you. To me, the right vision really is the golden goose is innovation. And you can do a lot of things to sort of batter markets, maybe even make them a little less efficient. But if you preserve the incentive to innovate, you're still going to have a lot of consumer welfare. So at the end of the day, these more marginal things don't bother me. It's, are you really affecting their incentive to innovate? And this gets back to what Philip mentioned at the outset. You know, we need to preserve competition on the merits. Why? Because that removes this notion that markets should look a certain way. 10% share for 10 firms is a healthy, competitive market that we need to observe, and that's really where we get the innovation. That's not what the economic literature says. Innovation occurs in many different ways, and no surprise, depending on the characteristics of the market you're analyzing. So at the end of the day, what the best approach tends to be, and I think the ACCC at their establishment indicated this. I have this great quote. I found it, or a colleague of mine found it, I should say. 1993, under the Competition Policy Review, it stated, the greatest impediment to enhance competition in many sectors of the economy are the restrictions imposed through government regulation. And, you know, this was the establishment of the ACCC when it made sort of this comment along with that. And I think it's very critical, because what you want to do is to allow firms to thrive on the merits. That doesn't mean laissez-faire. It doesn't mean we don't have any antitrust laws. But when we do anti-regulation, it's a presumption we know that this is a betterment for competition. And as this discussion, I hope, is illustrated, we're not there. And so if we're not there, we can do a lot of damage to these markets and not allow firms to compete on the merit, actually quite the opposite. So to me, that's the path forward. That's the philosophy. It's served us quite well. And I think we should be cautious to move to something different.
Thanks, John. Stephen.
Yeah, I'm basically going to echo John here, and also something that came up at the ACCC Reg conference last week. So, you know, think back over the last 30 years and think about, well, what's changed in the world? And the biggest changes around communications, the internet, you know, being able to do things like this webinar that literally were impossible 30 years ago, were impossible probably about 10 years ago in the case of a webinar like this. That is a huge improvement in welfare for, you know, call it consumer welfare, call it just the welfare of people around the world. Yeah, and there's been massive investment, there's been massive innovation in these areas of communication, particularly online communication. And yeah, we don't want to stuff it up. And you know, a bit like John, I sort of feel, well, you know, there's a lot of good stuff happening here. The last thing we want is to pick an area and let's say digital marketplaces, or, you know, we could do the same with other ACCC interim reports. We could look at search, or we could look at app stores. And we could say, hey, think of the massive benefits that we've got from better search, from having apps on our mobile devices, from having marketplaces. And do we really want to risk that? Do we want to say, hey guys, let's stuff it up and make it hard for these businesses and send their money off somewhere else? You know, I'm naturally conservative to interfere in these areas where you're seeing so much innovation. And, you know, comes back, I think, Philip, you might have mentioned earlier, what somebody mentioned earlier, you know, one of the earlier cases, the Microsoft case. You know, you look back and you almost sort of laugh now. Wow, yeah, it was a long case. By the time it was resolved, the market had moved on. I get a little worried here. You know, we'll resolve all of this and we'll come up with brand new laws. In the meantime, the world will have moved on, and all we do is, you know, stuff up something whilst the action's somewhere else.
Philip, you started, so you get the last word.
Thank you. You invited us to articulate a vision. I don't want to articulate a vision. I want to plea for modesty. I think there are lots of things we don't know. Even economists don't know. And so I think really we should only act if things are really bad. And so I think a lot of impatience, say, with our monopolization provision, Section 46, is because people get impatient. People somehow think there should be a lot of action, whereas I think perhaps it's a field that there shouldn't be a lot of action. I mean, things, unless something is really bad and obviously bad, then I don't think we should do anything. A great hero of mine among economists, Alfred Marshall, looked forward to the day, he said, when economists would be modest people like dentists. He said, well, my father was a dentist, and I'm not quite sure about the modesty, but I do think that we have to be modest as economists, and indeed as people advocating changes in policy. There are lots of things we don't know, and we should be very cautious.
Well, thank you. Thank you very much, Philip, and thank you to all of our panelists for what was, I hope everybody agrees, was a really interesting discussion and debate, and lots of ideas are exchanged, and everyone can continue the discussion elsewhere as we continue to consider these difficult issues around the world. So thank you very much to each of all our panelists, and thank you all to everybody who's participated in the chat box and who's attended the webinar. I hope you found it enjoyable and stimulating. Thank you, everybody.